Any opening statements from either party? Mr. Ojak.
No opening statement.
Ms. Dehart, is there anything you'd like to say for an opening statement?
Yes, that paper.
I am asking that you, this is an appeal on a case. I just want to make sure you have a photo with you.
Ma'am, that's not the appropriate way to enter evidence.
Okay, you should have a copy of it, is what I'm saying. I'm sorry. So what I'm trying
I don't
to...
have any, ma'am, I don't have anything.
Oh,
Okay.
at the time of the appeal.
Okay, at the time that I made the appeal, I made this photo, and I have others available, and they received it at the court, and they said that it would be with the paperwork. So I can either show it to you now, but what I'm trying to let you know is that I'm asking for an appeal on the magistrate's
appeal, ma'am.
ruling.
The appeal.
I'm
This is
appealing.
your
Right. So I would like you to...
All right, folks, buckle up, because today's courtroom isn't just hosting one confused defendant. It's hosting a tag team. We've got a self-represented Karen who believes confidence can replace procedure. And she didn't come alone. She brought her Kevin. This is an appeal hearing, which already puts her on thin ice, because appeals are about law and record, not vibes, feelings, or low-resolution photos printed at home. What you're about to see is a masterclass in how not to argue your case, interrupting the judge, misunderstanding evidence rules, and mistaking rambling for relevance.
My question for the officer is that
You have.
I'm trying to do this correctly, so if I do anything that's wrong, I appreciate when you correct me. So my question for the officer is that I changed my lanes with my, well, that's not for the officer, but I always use my turn indicators when I change my lanes. I guess I'm a little confused about the fact that
You ought to
is
give
not
Mrs.
at
questions
all
at this point.
that was...
Ms. Dehart, can you ask questions?
Oh, God.
The opportunity to testify. It's your opportunity to ask the officer questions about what he had just testified to.
Okay, that this testimony that he is saying now is not what was testified in the previous magistrate court. He's changed his testimony from then.
It's
And
not your turn to testify. It's your turn to ask him questions, not me.
Yeah, I'm asking,
Answer
okay,
questions.
I'm sorry, I'm asking him why he's changed his testimony. All of this information is not part of what was at the magistrate. So why did he change this? I do want to know, did he go back and check the lane usage, which is what I was told, that it was improper lane usage because the court...
This right here is where things start going off the rails. Karen believes that simply having a photo automatically makes it evidence. But that's not how court works. Evidence isn't just about what you bring. It's about how you bring it in. You need foundation, authentication, and proper admission through testimony. The judge isn't being nitpicky. He's enforcing the most basic procedural rules. And notice how patient he is. Instead of shutting her down outright, he explains the issue and gives her space to correct course. But Karen doesn't slow down. She keeps talking, keeps apologizing, and keeps missing the...
And say that it's not for improper lane use when that's what we did in the previous magistrate. Why is this testimony different than what we talked about in the previous? I was told specifically by the magistrate.
Ma'am, one question at one question at a time. Let him answer.
Okay.
Okay, my testimony in this case is a little more detailed than it would have been in the informal hearing. And the reason for that is, and I actually took measurements on Google Earth and the Washtenaw.org mapping system. That's how I had the exact measurements of the signage, where the road markings were, et cetera. As far as what you were stopped for, you were stopped for, it could be improper lane use. It could be the fail to yield for merging over. There were a number of violations that would have been appropriate. and I ended up issuing the impeding because that's a 0 point.
But I asked you, why did you change your testimony? Because the, it's called an informal hearing. So you didn't really answer my question. My question is, why did it change from the lane usage, which the magistrate previously made it very, very clear that this was specifically regarding using the right lane to go through, and that the right lane, she repeatedly said that the right lane is a right turn only lane clearly marked, which it is not, and I have proven that.
This is one of the most important moments in the entire hearing, and Karen completely fumbles it. The judge clearly explains that this is her opportunity to ask questions, not to testify, argue, or narrate her own version of events. Cross-examination is about precision, short, focused questions that let the witness speak. Instead, Karen stacks opinions, accusations, and commentary into one endless sentence. And here's the irony. She actually stumbles onto a potentially valid question about changed testimony, but she buries it under rambling. The judge even points out that her first question was legitimate. All she had to do was stop talking.
Sir, is the officer aware that at the intersection of Michigan and Riverview, the lane signage that's posted clearly indicates that there is a left turn lane, there is a straight through lane, and then there is a straight through and right turn lane? Is the officer aware of that?
There are, as you're coming eastbound, I'm assuming you're talking about the eastbound lanes. As you're coming eastbound, there is a left turn lane that goes north onto Austin Road. And then there are two other lanes, the inside lane and the curb lane. And both of those are allowed to go straight through at that point.
Right. And that's what I did. And that's what you testified to. And I clearly, why are you changing your testimony? Are you just trying to keep my money? That just doesn't make sense to me.
Sustained.
I agree with you. It's not appropriate, but I'm very sorry, Your Honor. This is clearly not appropriate either. It's a very, okay. And then I would like to say, I do have a witness.
Miss DeHart, if you have any further questions for for Officer Belknap,
No.
we have any further questions for him?
All right. Is Officer Belknap aware that I had someone else in the car?
Yes, you had your husband, and he made it very clear that he worked for a police department. And I felt that he was actually trying to get you some courtesy for that. And in fact, that's perhaps why I issued the impeding traffic and not the traffic violation with the points on it.
Can I talk?
This is where the officer calmly dismantles the entire changed testimony narrative. Informal hearings are summaries. Formal hearings require detail. That's not inconsistency. That's procedure. He even explains that he took measurements and verified signage using mapping tools, which strengthens the credibility instead of weakening it. And then comes the real kicker. The officer admits he could have cited multiple violations, but deliberately chose the least harmful option. 0 points. Minimal penalty. That's discretion working in Karen's favor, whether she realizes it or not. Instead of appreciating that, she takes it as proof of wrongdoing.
He was making himself aware because of a courtesy to other police officers. And he made it very clear.
Ma'am, you cannot testify right now. And everything you're saying, I am not taking into evidence. You have
I'm very sorry, Your Honor.
Ma'am, it's my turn to speak.
Okay.
Opportunity to cross-examine the officer. If you have any questions for him, you may ask him questions, but your questions are not evidence. So you do not go off on all these other things that the magistrate was talking about, because I'm not taking note of any of that. Those are not evidence, those are just questions. What the officer is saying is the evidence that I'm going to take into account. So if you have any further questions that you would like to ask the officer, please do so.
Thank you. Then another question that I have is that the officer was not the only one in attendance. And could he please tell me, there was his supervisor or whatever their ranking is, was also there. And
What is the question, ma'am? You're testifying again. Can you
Like,
please ask
what-
the officer a question?
okay, so what was the other officer there for, other than him? Yeah. And
That was-
was he, oh, I'm sorry. I'm very sorry because I'm saying sorry too much and I'm not used to court proceedings. So I apologize for all of that. So is there something we can, I maybe would like to revisit this again because the courts did not receive, I have a copy that said they received it and none of it's with the file. And I just feel really,
Ma'am, if you
Like
have
Shanghai,
evidence that you would
but-
like to use, then you can certainly try to admit that evidence through a witness. You can't just hand me documents.
right, you mean like the court? As a witness, submit documents through a witness, which would be
Through
the
their
court.
testimony.
Okay, well, so I can have a witness?
All right, welcome back. And yes, that sponsor break probably lasted longer than Karen's attention span for courtroom rules. But notice what the judge just did. He gave her time to think, regroup, and hopefully figure out how to ask a clean question. That's restraint. Most judges wouldn't be this generous. This pause actually helps the defense more than the prosecution because it resets the pace. Unfortunately, Karen comes back with the same problem. She asks a question, gets an answer, and then immediately argues with it. Courts don't work like comment sections.
Kevin D. Hart.
Okay, does he have another device or something he can?
I'm right,
He's right next to me. Is that what you want?
I'm right here.
Okay.
And please tell me if my window.
Can you
is
raise
too
your
bad.
right hand, sir? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
Lower your hand, state and spell your name for the record, please.
Kevin Dehart, Dehart. The first name is Kevin.
Go ahead, Ms. Dehart.
Okay, first of all,
No, sir, you can't
what?
just start talking. Ms. Dehart can ask you questions.
oh,
You're
I'm sorry.
the other witness. You can't just talk.
I'm sorry, I thought you said Mr. D. Hart, not Mrs. D. Hart. Were you in the car with me in November 10th, 2021,
Yes, I was.
as I was driving? In your professional opinion, with over 33
I'm going
years,
to object to the comment about professional
police.
opinion, Your Honor. And we'll stipulate to the fact that he was present in the car. The officer already testified to that.
Sustained.
Yeah. Okay, and did I do any illegal driving during that time?
No,
that
you
day?
did not.
At none, well, there would be none, so that would cover absolutely everything that was handled on that day, including the line markings that do you believe that the officer's statement about where all the line markings are on the road and where the dotted lines happen in the road and where the lane ends and the usage, does that include that all of that was done legally?
Yes, it was.
And do you believe that the officer has changed his story from the hearing that we were
I'm going to
in?
object again,
Oh,
Your
wait,
Honor.
that was.
We're
that was
talking
when I
about
was talking
testimony
about-
and it-
I'm sorry. I just remembered
Sustained, Ms.
that.
Dehart. Please
Yes.
move on from the informal hearing.
Thank you. I'm sorry, I forgot about that. So do you believe that the officer's testimony today is not accurate and not true to what he told us when we were pulled over?
Objection again, Your Honor. She's going back to the same thing that you just told her not to do.
You're gonna get a lawyer.
Yeah, I think I need some representation.
This is.
I don't know how to handle it from now.
And here comes Kevin, unintentionally confirming that this ticket was already a gift. The officer openly states that Kevin's law enforcement affiliation influenced him to issue a lesser citation. That's not corruption, that's courtesy, and it actually undercuts Karen's entire appeal. Instead of showing bias against her, it shows leniency for her. The judge immediately steps in to stop Karen from testifying again, because at this point she's arguing herself deeper into a hole. This is one of those moments where silence would have helped her case. Instead, Every word strengthens a record against her.
Ms. DeHart, do you have any questions about the November 20th?
November,
Mr. DeHart,
on November 10th?
I'm sorry,
Okay.
November 10th.
Yeah.
Do you have any further questions for Mr. DeHart about
So
November?
I'm going to go ahead and go along with you, and I'm going to say that there is nothing else at this time that I'm just all shooken. I'm totally shooken up. Okay. Totally shooken up because okay, I'll stop there to try to be more appropriate to you. Your Honor, I'm very sorry that we have to take up your time on this because I think that you have not been told the truth in this case. So my closing statement would include that I wished the court proceedings worked and you had the paperwork in front of you that you need, and that the officer's story has changed in three different times. And I just don't know what else to say. I just would appreciate that you dismiss this and we can have our money returned, because as everyone knows, money is very tight these days. And living with an officer for 38 years, I appreciate and respect everything about the officers. I was the one that was insulted when he made comments about himself, because that is...
This is where things go from bad to brutal. Kevin takes a stand and immediately violates the most basic rule. He starts talking without being asked. Then comes the 33 years of experience claim, completely unsupported, unqualified, and legally meaningless without foundation. Courts don't accept vibes, resumes, or marital loyalty as evidence. And when Karen asks if she did anything illegal, Kevin predictably says no, which carries zero weight because it's opinion, not fact. The judge sustains objections left and right, and you can feel the case collapsing in real time.
I'm not going to go into about everything that happened before. There's a lot of things you just said, which I could really point out. I want to make two statements. What she provided to the court, if it had been provided to you, court staff would have been violating the rules, as they're not allowed to, she's not allowed to provide evidence ex parte to the court without providing it to the prosecutor too, and that would be done in trial. My second statement is regarding all the things she has said several times about Officer Belknap. I have decades and decades and decades of experience, and I actually know Officer Belknap very well, and I consider him one of the most professional and best officers I've ever had contact with. That's all.
Thank you, Mr. Ojak.
Can I answer to that?
No, you can't. The way that it works, the prosecutor, because they're bringing the case forward, they get the last word because they have the burden of proof.
Well, because...
No, Officer Belknap, as well as the testimony from Kevin DeHart and Lisa DeHart. I wanted to address a couple of things. There was a lot of conversation about a photo that Miss DeHart that she submitted to the court. It is correct. It wouldn't have been appropriate for her to not also include the prosecutor in that communication. Nonetheless, it became clear through her own testimony of what this picture would have reflected. And from the officer's testimony, it doesn't sound like this picture had any relevance to what this impeding traffic ticket is about. So had it even been submitted, I'm not sure if it would have been appropriate to bring forward in this case, because what the picture seemed, what I believe, or what it seems that Ms. DeHart was saying that the picture was portraying had nothing to do with why she was pulled over. So I'm not sure that picture had any relevance. So I believe it wasn't actually submitted. Ma'am, you cannot speak.
I'm sorry.
Ma'am, you cannot speak. As far as the testimony, we did have testimony from Officer Belknap about what happened that day, what he witnessed, he was on the lookout based on the dispatch had given him some information about to be on a lookout for a vehicle, that there were some complaints about a vehicle. So he was certainly paying attention to what was happening at that intersection. He witnessed Miss DeHart's vehicle sort of force merge herself beyond where the lane had actually narrowed, despite there being two other signs indicating that the right lane was ending. And Officer Belknap also indicated that he witnessed the vehicle behind Miss DeHart's vehicle that she cut in front of had to slow down. After Officer Belknap's testimony, there was no testimony offered from the other witnesses that testified about what exactly happened at that intersection and that merge. There was no explanation or alternative facts given to what may have happened at that intersection that perhaps Officer Belknap may have confused or may have missaw. There was just no testimony given about what happened at the intersection at all. I did find Officer Belknap's testimony.
At the end of the day, this case isn't about lane markings. It's about preparation, procedure, and knowing when not to speak. The judge followed the law. The officer provided clear and consistent testimony. And Karen unfortunately proved why self-representation is risky without discipline. Appeals demand precision, not persistence. And the harshest lesson here? She already had the best outcome possible and talked herself out of appreciating it.